And actually, I think this should resolve fairly quickly. The state initiated its request to you for the comfort order based on representation that Mr. Eyman was making at petition filing and then subsequently in the state court that the automatic stay under 362 applied to all those civil proceedings and that they would then be halted. That was a position undertaken by his co-defendants, also counsel for co-defendants at the same time. So in abundance of caution, we brought this matter to the court, explained why the exemption under 362b4 applies to the state's proceedings as an exercise of the police and regulatory powers of the state. Mr. Eyman then reversed course and conceded that, in fact, that particular exemption section does apply to the exercise of police and regulatory powers by the state. And so at this point, we don't think there's anything left in controversy, and we would ask the court to sign the order that we proposed, which indicates both that the state's civil proceedings, both the two that have been identified to you, State versus Eyman et al. And the State versus Tougher to Raise Taxes et al. Are the exercise of the state's police and regulatory powers, and that the state court proceedings in each of those cases can proceed.
All right, let me get clarification on part of your reply. So Mr. Feinstein's come back and appropriately indicated that even though he concedes, as I read it, concedes that the regulatory powers exception applies, and therefore there is no stay of the state's two state court actions against parties, including Mr. Eyman, that enforcement of any monetary judgment that's obtained in those proceedings is stayed. I read your reply as sort of saying you didn't necessarily disagree with that, but you didn't think it needed to be in the order. Is that an accurate characterization of the state's position? You're not disagreeing that you'd have to come back to me for any relief from stay as to enforcement of a monetary judgment?
That is accurate. What the point we were trying to make is what happens post-trial in January 2020. Whatever status this bankruptcy is in at that point, whatever status those cases are in, that's the time period that will control what happens. I don't think you can predict either what's going to happen in the state court with the enforcement proceedings and any penalty that may be assessed or injunctive relief assessed against any of the parties, just as you cannot predict whether this proceeding will still exist at the time of any action by the state court. So we didn't believe it to be necessary to include any kind of statement in there to that effect. It wasn't necessary in order to exercise the state's right to proceed in state court. That was the point we were trying to make.
All right, thank you. Mr. Feinstein? I mean, given that, do we really have any controversy? Oh, I'm sorry. Ms. Marc, were you intending to...
With respect, since I haven't been appointed as counsel, the problem that arises is that, for example, in State v. Tougher to Raise Taxes, that's a case where when I was brought in the day after filing, there were apparently settlement discussions had been bandied about, no answer filed. The state demanded answers. Mr. Lamb is filing answers, I understand, on behalf of co-defendants on Monday, but he absolutely does not represent Mr. Eyman at this point. I'm loath to substitute him as counsel when you haven't appointed me. So while we agree that police and regulatory power exception applies, Mr. Eyman is effectively unrepresented in two cases, at least until the 17th. And they are significant cases, large matters that have been going on, one of them for several years. One of them, the state indicated they plan to start discovery immediately, and yet he'd be proceeding pro se, absent an appointment of special counsel for it. So I think that's the issue here, is Mr. Eyman does need some representation, whether I'm the best he can find anywhere or second best. He needs some counsel on these matters, and so to allow them to proceed pending the bankruptcy court's appointment of counsel, I think is unfair to Mr. Eyman.
Mr. Feinstein, let me turn back to you on a question on the prior applications. You requested those all to be retroactive, didn't you?
Well,
or did
I'm not
you?
sure. It's the bankruptcy court's order on. even granting relief from the stay not effective for 14 days anyway. So it wouldn't become effective for 14 days anyway, and that would cover potentially getting nothing that would happen. And
well, Chris, I wouldn't, if I'm granting what it sounds like everybody agrees is the state of the law, I'm not granting relief from stay. I'm just determining that there isn't a stay.
Okay. Well,
so the 14
as Mr.
days
Art pointed
won't
out,
matter.
apparently is there actually a motion for default or something? And okay, I wasn't aware.
Well, back to my original question: Are you asking for retroactive approval of counsel in the applications?
Yes.
I mean, I don't mean did you intend to. I could look back at them, but did you ask for retroactive?
The applications are retroactive, aren't they?
Yeah.
Yes.
Yeah.
Yeah.
We did.
Okay. And I don't think there was any objection by the state to the retroactive aspect of the applications. I'm not sure you made the clearest showing for what you need to show on that you need to make, but nobody objected to it.
Okay.
And I don't sua sponte as you've seen from prior practice, for this short of a period of time of retroactivity, I don't inherently have any problem with it.
We'll get it covered.
All right. So that's going to turn back to Mr. Art's concern. Hang on a minute. All right, so the state has requested a comfort order. I'm gonna go ahead and read a ruling. Although the parties are in general agreement with the relief, I think it's just going to be a cleaner record if I just walk through it and read it, even though it's going to be longer than it really needs to be because of what's, for the most part, an uncontested matter. But let me address Mr. Ard's concern before I even raise it, which is my determination is there is no stay. So I'm not going to impose a stay where there isn't a stay, just to allow for the time gap for an order employing Mr. Ard as counsel. I mean, that's just a risk he's going to have to take. But you've got pending a retroactive employment application. Assuming I grant that employment application, you will then be qualified to move for fees in connection with the work you're doing. The fact that you haven't been employed yet doesn't disqualify you from representing the debtor in the state court action. It just puts you at risk of whether you're going to be paid, whether there would be some sanction for moving ahead and representing the debtor without an employment order. But just as Mr. Feinstein has taken that risk up until today of acting for the debtor in the bankruptcy proceeding, it's just a risk counsel in a Chapter 11 proceeding always take, because you never get the employment order, or very rarely get the employment order entered the same day as the bankruptcy. At least that's not the custom in this proceeding. So I'm not going to address that issue. The ruling's going to be there is no automatic stay as to these two state court actions. So, and I'm not going to impose one just because you fear some risk until there's actually an employment order for yourself. So this matters before me on the motion for comfort order, recognizing automatic stay exemption for the state's regulatory lawsuit seeking civil penalties and injunctive relief. Hereafter, the motion for comfort order filed by the state of Washington. The state seeks an order declaring that it's exempt from the automatic stay in its prosecution of two lawsuits against Timothy Eyman, hereafter the debtor, Debtor's response at docket 24 does not oppose that, but rather seeks to limit the scope of the comfort order to expressly provide the exception to the automatic, the exception to the exception, if you will, to the automatic stay, and that exception shall not apply to enforcement of a money judgment. Having reviewed the pleadings and having heard arguments of counsel, I grant the motion. I have jurisdiction under 28 U.S.C. Section 157b1 and 1334. The motion for comfort order was brought under Bankruptcy Rule 9014. It does not appear that I need an adversary proceeding to grant declaratory relief under Bankruptcy Rule 7001. C. In re Thongta, 2009, Bankruptcy Lexus 1428 at 2. Bankruptcy Court, Eastern District of Wisconsin, June 15, 2009, holding that proceeding for declaratory relief regarding the automatic stay does not apply, and a contested matter that you don't need an adversary proceeding for a declaratory relief request as to the automatic stay, and that a simple contested matter is sufficient. Debtor filed his Chapter 11 petition on November 28, 2018. The debtor is the defendant in two state court actions, State v. Eyman in Thurston County Superior Court 17-2-01-54634. It's a civil enforcement action related to three entities for alleged violation of campaign finance laws, an alleged kickback scheme, and in it, the state requests civil penalties, injunctive relief, costs of investigation, court costs, and attorney's fees. There's also, and I need to address this slightly, even though the parties didn't really deal with it, during the procedure there was a sanction for failure to comply with discovery, and the court's been imposing a penalty of initially $250 per day, which was later increased to $500. The second suit is the State of Washington versus Tuffer to raise taxes et al., but included as a defendant Mr. Eyman. It's Thurston County Superior Court case 16-2-03891-34, and it involved three now consolidated cases against political committees for which the debtor served as an officer. The claims include failure to timely and accurately file reports of campaign finance contributions and expenditures, failure to properly account for loans received by the political committees, and three, failure to report candidate opposition expenditures. The suit seeks remedies under RCW 42.17a.750, including civil penalties, injunctive relief, attorney's fees, court costs, and court investigation. Now, the analysis section I will try to cut short, but despite litigation generally being stayed under 11 U.S.C. Section 362A, 362B4 provides an exception for, quote, the commencement or continuation of an action or proceeding by a governmental unit to enforce such governmental unit's police and regulatory powers, including the enforcement of judgment other than a monetary judgment obtained in an action or proceeding by a governmental unit to enforce such police or regulatory power, close quote. There are two tests in the Ninth Circuit for that. One is called the pecuniary purpose test, and one is the public policy test. See In re Dingley, 852, F3rd, 1143 at 1146, Ninth Circuit, 2017. Satisfaction of either test will suffice to exempt the action from the reach of the automatic stay. Pecuniary purpose test. Under the pecuniary purpose test, the court determines whether the government action relates primarily to the protection of the government's pecuniary interest in the debtor's property or to matters of public safety and welfare, close quote, id. If the government's action is pursued solely to advance the pecuniary interest of the governmental unit, the stay will be imposed. For example, if a state were merely collecting taxes, suing on a contract, or pursuing a tort claim for injury against the state, it would generally be construed as advancing solely a pecuniary interest. Here, the state's actions against the debtor are not brought to remedy a monetary injury to the state or some other pecuniary purpose, but to enforce state campaign finance laws. Enforcement of the state's campaign finance laws do not relate to a pecuniary purpose, but rather public safety and welfare, and that would be the case regardless of whether a monetary judgment is obtained or not. I therefore conclude that under the pecuniary purpose test, the state court litigation at issue falls within the regulatory exemption under 362b-4. The public policy test, which is the alternative test, distinguishes between government actions that effectuate public policy and those that adjudicate private rights. Here, the state seeks to enforce laws directly affecting the public's right to disclosure and appropriate use of political campaign funds. See RCW 42.17a.001. Since the two state lawsuits are not intended to adjudicate private rights, the public policy test is also met. Additionally, under that In re Dingley case I just cited, pursuit of sanctions against a debtor to deter litigation misconduct is also generally accepted from the automatic stay under that same provision, 362b-4. So even if this had been a different kind of a lawsuit, that aspect of it would not be stayed. The debtor correctly points out that 362b-4 does not provide an exemption for enforcement of a money judgment, even if obtaining the money judgment is exempted from the stay under the regulatory powers exception. The order approving the state's request for a comfort order should therefore specifically include reference to that limitation. These kind of comfort orders are as much for the superior court's benefit as anything else, as they should define what is stayed and what isn't stayed, and part of that is the fact that enforcement of a money judgment is not stayed. Remains stayed. So I would add to the state's proposed form of order, which I otherwise found acceptable, a modification to the last sentence to add a new last sentence to add, the state is hereby authorized to proceed in state court with these state enforcement proceedings except as provided below. So the except as provided below would be added to the present last sentence, and then a further I don't know if it's paragraph or sentence within the same section, but a further sentence should be added right after that, quote, enforcement of any, quote, money judgment, close quote, as that term is used in section 362b-4 against the debtor or assets of the bankruptcy estate remains subject to the automatic stay, period. That's the end of what I need as far as an insert. Any debate as to what constitutes a stayed action to enforce any monetary judgment that might be obtained can be addressed by further motion. The reason I mention that is I think Dingley raises an interesting issue of, is a sanctions award by a state court judge a monetary judgment for purposes of 362b-4? I don't have an easy answer on that. So if the state's going to take on collecting those sanction awards with its remedies that would normally be followed from a monetary judgment, I think you ought to think good and hard about whether you need to come to me for either a further comfort order or for relief from stay. And I would say, in general, I wouldn't normally grant an unsecured creditor relief from stay to have at assets of the estate. So your odds of me granting such a motion would be slim, at least at this juncture. All right, any questions on the form of the order?
No, as at the actual form of the order, do you just want us to modify the order that we provided to you with the additional
right, so
sections
modify it,
okay.
Have Mr. Feinstein review it, and then upload it as a received unsigned order.
Okay, we will do that. And then with respect to, just a quick question about the discussion you just said about sanctions, because the courts, the superior courts, contempt sanctions are still running at this point, even if the trial court were to affirm the special master's discovery order that Mr. Eyman himself had purged contempt as of sometime in November. That is an issue the trial court will be
So
taking
under that
up.
Dingley decision,
Yeah.
the trial court can do whatever the trial court does on with a sanctions request for discovery or any other kind of litigation abuse. The question I raise is, you as a party trying to collect on that sanction, what are your, is that collection on a monetary judgment that is stayed?
Right. Just I wanted to make sure that you and I were on the same page about
Yes.
what that meant.
All
So
right.
thank you.
All right, any questions from your end, Mr. Feinstein? All right, thank you.
Thank you, Your Honor.
And we will be at recess.
All rise.
Good afternoon, this is Judge Barreca. Do I have the parties